Assalamualaikum. Good day to Dr. Muhammad Nazrul and everyone watching. We are Group 9 and today we will be presenting our video case review on shipping law assignment 2. So our presentation centers on landmark maritime cases which is Wahab bin Ibrahim and others versus AET Tankers Holdings Berhad. This case was cited in 2012. So to understand the legal battle, we must first look at the complementary issue. So on May 2000, on 35 May 2010, a severe maritime casualty occurred within the Singapore Traffic Separation Scheme. The Malaysia registered Alpha Mac tanker, MT Bunga Kelana 3, carrying light crude oil. It's actually collided with a bulk carrier MV Valley. So the impact catastrophically ruptured the tanker's whole hulls, spilling approximately 2,500,000 of crude oil into the sea. The public and the economic impact was severe. The oil drifted into a coastal waters of Penang, Johor, causing widespread contamination to the marine ecosystem, mangrove habitat, and local aquaculture. Consequently, fishing activities were disrupted. This led to a large-scale representative action filed in the High Court Johor Bahru by Wahab bin Mahim and 248 others local fishermen against shipowner. The AET Tanker Holdings claiming a massive general and special damages for lost income spanning over 6 month period. For this massive suit had to resolve three core legal issues. The first one, the local standby. Did the plaintiff have the legal standing to claim for damages for lost income if they lack a valid fishing and vessel licenses under the Fisheries Act 1985? The second one, the adversarial standard. Did the plaintiff provide a sufficient legally acceptable evidence to prove a certain economic loss of 6 months? The third one, admissibility. Were the independent loss adjuster and affirmative report were admissible, or did they just amount to an unverified hearsay?
Alright, thank you. To evaluate how this issue were treated, we must balance two distinct legislative frameworks: domestic maritime law and international shipping convention. First, Merchant Shipping Oil Pollution Act 1994, MASOPA, which domesticate the International Convention on Civil Liability for Oil Pollution Damage, CLC 1992. Under Section 3 of MASOPA, strictly enforce liability directly upon ship owner for oil pollution damage within Malaysian waters, removing the requirement for victims to prove negligence. However, international shipping law balanced this strict liability by giving ship owner the explicit statutory right under Section C to limit their financial exposure by establishing a single limitation fund based on the vessel's gross tonnage. This prevents catastrophic corporate insolvency from a single navigational error. Crucially, this strict framework intersects with the domestic public policy via the Fisheries Act 1985. Under Section 8 and Section 11 of this Act stated that engaging in fishing or operating a fishing vessel without a valid license is a criminal offence. Furthermore, we must look at the judicial precedents like Spartan Steel and Alloys Ltd. And Martin and Co. 1973. This case established a clear boundary between legally accepted direct losses or pure economic losses in shipping law to protect limitation found from infinity inflation claims the hypothetical commercial loss or speculative. Furthermore, we must look at judicial precedents like Spartan Steel and Alloys Ltd. And Martin and Co. in 1973. This case established a clear boundary between legally accepted direct losses and pure economic losses in shipping law to protect limitation found from infinite inflation claims the hypothetical commercial loss or speculative market disturbance are generally excluded unless direct, quantifiable damage can be strictly proven. My colleague will now analyze how the High Court apply this rule.
Thank you. As a legal analyst, in a landmark judgment, presiding Judge Vernon Ong J acted as a strict gatekeeper, filtering out claims at the liability stage rather than the quantum stage. First, on the issue of licensing, the court applied the classic legal doctrine of ex turpi causa non oritur actio, meaning no legal action can arise from an unlawful cause, because 199 of the plaintiffs fails to produce valid fishing and vessel licenses, their fishing was an offence under the Fisheries Act 1985. The court drew an adverse inference under Section 114G of the Evidence Act 1950 and completely dismissed the claims of those 199 unlicensed individuals. Only 50 lawfully licensed fishermen were granted legal standing. Secondly, regarding the duration and evidence of the loss, the court heavily criticized the plaintiffs' claims. The plaintiffs asserted a 6-month fishing ban, but their own oral testimonies contradicted their claims form. Furthermore, their independent environmental reports were rejected as inadmissible hearsay because the authors relied strictly on unverified stories from the fishermen and could not be cross-examined. Instead, the court accepted validated scientific data from the Department of Environment and the ITOPF report, which proved that the light crude oil patches had evaporated or dispersed within days. Consequently, the court drastically reduced the compensable period from 6 months to precisely 5 days. In conclusion, the primary lesson learned from the Wahab Ibrahim case is the statutory limitation frameworks and civil standards of proof function together as vital judicial control mechanism. While maritime laws enforces strict liability to protect the victims, the courts will also robustly guard against speculative, undocumented or unlawful economic claims, keeping ship owners' total liability exposure within rational and also legally recognized limits. Thank you.